Good morning to all dignitaries, department heads, faculty members, students, and all our viewers. We've gathered here again on this platform of Institutional Innovation Cell of Sistikar, this time to discuss about intellectual property rights, in short, IPRs. IPRs are rights that protect and provide exclusivity towards intangible creations of human intellect. Recently, the world celebrated the 21st World IP Day on 26th of April 2021, and the WIPO, World Intellectual Property Organization, proposed the theme for the year 2021, the role of small and medium enterprises in the economy and how they can be used um, to build stronger, more competitive, and resilient businesses. In line with these global celebrations of IP Day, the IIC Systec R too brings this expert talk for creating awareness about IPRs and its significance for startups. How we can approach to file IPR, what are the various steps for IPR, and the questions alike. I hope this session will help our students and viewers to find answers to such questions. So let's begin the session for today. I request Professor Ajit Srivastav, Head of Department Computer Science, for the welcome address. Sir.
Thank you very much, ma'am. A very good morning to all of you. Honorable Chief Guest Speaker of the day, Ms. Sushi Agarwal, Founder and Managing Director Partner of IP Niti Noida, Chairman Sir Shri Sudhir Kumarji Agarwal, Managing Director Shri Siddharth Agarwal, Sister Group Director Dr. Jyoti Deshmukh, Principal Dr. Manish Villore, faculty members, and my dear students, I, Ajit Srivastav, warmly welcome you all to the live session on intellectual property rights and IP management for startups, organized by Institutions Innovation Cell of Sagar Institute of Science, Technology and Research, Ratibad Campus, Bhopal. Introducing to my group, Sagar Group came into existence under the visionary leadership of our Chairman Sir, Shri Sudhir Kumarji Agarwal. The group over the years has proven name in the fields of real estate, education, production, and manufacturing. Sagar Group also established an organization, Abhay Sagar Foundation, as a corporate social responsibility with a noble cause to uplift underprivileged sections of the society. It works in the area of healthcare and education. Sagar College is a group of technical education institutes committed to provide industry-oriented education with its unique pedagogy and hands-on trainings. This is achieved by the institutes through organizing summer and the winter training programs in different thrust areas of engineering, series of events and activities to bring out both corporate and cultural aspect of the students like Sagar Manthan, Nirmana, Systec Startup Meet, Tech Talk, participation in various national technical competitions like Hackathon, Toykathon, Chhatra Vishwakarma Award, etc. The students are also motivated for entrepreneurship so that they can serve the nation to become Atmanirbhar through Atmanirbhar Bharat. For all the above activities, our institute has taken initiative to be the part of Atmanirbhar Bharat by joining hands with important initiative of MHRD to promote innovation thinking and among the budding technocrats. Therefore, Institute has established Institutions Innovation Cell. Government of India has established Institutions Innovation Cell under the supervision of MHRD to foster culture of innovation amongst the higher education institutions. Primary mandate of MIC is to encourage, inspire, nurture young students by supporting them to work with ideas and transform them into prototypes while they are in the formative years. Institutions innovation cells majorly focuses on to create a vibrant local innovation ecosystem where students can nurture themselves, startup and entrepreneurship supporting mechanisms in higher education institutions, prepare institute for Atal ranking on innovation achievements and frameworks, establish function ecosystems and pre-incubation of ideas, develop better cognitive abilities amongst technology students. How these institution innovation cell functions? The functions are to promote innovation in multidimensional mode in the institute to an innovative to conduct various innovation and entrepreneurship related activities prescribed by Central MIC in a time bound fashion. Identify and reward innovation and share success stories. Network with the peers and national entrepreneurship development organizations to create an institution's innovation portal to highlight innovative projects carried out by the institution's faculty and students. The benefits which a student and faculty get through this initiative that the students and faculty associated with institutions innovation cell get exclusive opportunity to participate in various innovation related initiatives and the competitions organized by MHRD. They can win prizes and certificates every month, meet and interact with renowned business leaders and academicians. They get opportunity to nurture and convert their ideas into prototype ideas. They get mentoring from the industry professionals. This is what the institution's innovation cell can help out the students within the institution by creating this ecosystem. And when we talk about innovation and converting ideas into the prototypes, definitely that is intellectual property right plays a very important role in this key area. So with this introduction of my institution and the institution's innovation cell, I would like to welcome Ms. Shuchi Agrawal and over to Smurti ma'am. Thank you.
Thank you, sir, for this brief introduction. I welcome our guest for today, our expert for today, Ms. Shuchi Agrawal, and I take this pleasure to introduce our viewers to our expert. Ms. Shuchi Agrawal, the founder and managing partner of SS Intellectual Property Niti Consultancy, IT Niti. Ms. Shuchi is registered Indian patent agent with a graduate degree in electronics and communication engineering and PG diploma in VLSI. Also an LLM degree in intellectual property and competition laws from Max Planck Institute, Germany. Working in the domain since 2003, she started her career with top IT firms. She has an in-depth understanding of the evolution of the intellectual property rights in India. She is well versed in patent prosecution, asset management, litigation support, and patent commercialization. With a person of such expertise, we are sure our students and viewers will certainly benefit. Over to you, ma'am.
Thank you
The
so
platform
much.
is yours.
Thank you so much, and thank you for such a warm introduction. I hope my voice is easily audible
Yes.
because I hear a lot of background. Okay, all right, great. Thank you so much, Professor Srivastav. I think it's very, very heartening to learn about the activities that your innovation cell is doing. In fact, I think that is the need of the hour. This pandemic has really exposed that we need to get on our toes. Atmanirbhar Bharat is the need of the day. So with your cell arming your students, your faculty to actually go self-dependent, I think it's a commendable step. With this, yes, I think I'll try my best to answer and respond to the questions that Dr. Verma and you have touched upon in the limited time as we could. I think the way I would want to structure, and I hope this is going to be meaningful and a value add to all our audience, is I wouldn't really get into much of the theory, but I would talk about how strategically IPR could be helpful to them and what are the pitfalls or traps that they can get into that they should avoid. Given that we are innovators who are working on it, we typically do not know what is law. We might read upon because we love Google. So we think the first answer should be we just put a keyword and whatever initial information we get, just absorb that. Is that really something that can save us or destroy us? And what to do, what not to do? I would just arm to do a little bit on that front. And I hope that's going to be helpful. So with this, I'm going to start my presentation and right away get started with the topic. It's actually not showing my PPT, that I don't know why. Is the PPT already available? Is it appearing?
No. It's not.
So it's actually not showing. Yeah, so when I'm saying click, when I'm clicking on share screen, then it's not giving me the option of sharing the PPT. Maybe I should restart and see.
In the chat box, ma'am, article.
It's not taking this.
You need to click share button in the bottom.
Yeah, I did that. But no, actually it's not showing that. So it's only showing me 3 screens, none of which are the ones that I need to share. Okay. I think I might have to log out and log in again. Should I do that? Yeah, it's saying that your browser has blocked your screen.
Pankaj, sir.
Okay, so maybe I can do without the presentation, but I think it would have helped if I would have shared the screen. It's not allowing me to share the screen now. Yes, there we go. All right. Is my screen now available? Can everybody view it?
Yes.
All right. All right. Great. So essentially, I start with saying that every year we have amazing innovations. There is no dearth of the same. And if we look about, then researchers actually roughly provide this number that there are about 100 million new businesses that open around the world. This is a big number. Imagine if most of these are successful, possibly Earth would be a better place. But honestly, the journey of such startups is not very, very easy. And there are a number of challenges which are associated, which are like having a good business model, trying and refining those, financial constraints, which is obviously, and I think one of the major concern of a startup, they have limited resources to stand by. The product or the service that they're offering, the quality of the same, the technicality associated, have they really fetched that out? Do they have enough customer base that can support them in their journey and make them go from step A to, let's say, the next step, rise higher up? And last but not the least, the legal matters. With these challenges, even after this, there is no dearth of innovation. However, the sad part is to see this. The survival rate is roughly 10% around the globe, which means that 90% of the people who are doing startups, if we assume that even some percentage, 20 to 30% of this failure is also dealing with products which are absolutely new or they are path breaking, they also don't see the light of the day. So largely what could be the problem areas that we are talking about? So different studies have proposed a number of problems. Largely, if I have to bucket them out, I would say that we talk about problems related to the business model that they have. Some of the startups falter because they really do not have good talent at hand. Some of them, they don't have good product launch. They are not able to create a market whatsoever. But the foremost, or in fact, the last in their list, which is a problem area, but not much recognized, is a legal problem as well of not being able to handle their legal matters well. So if I look about it only in terms of IPR, because when I talk about legal, it's a big game. We talk about civil, we talk about different other facets, taxations, etc. But largely focusing only on the IPR part where they falter in the legal thing, what I've done is I've actually categorized it into 5 these different heads. And I would try and explain these heads, not as theory, but taking live examples of cases that I've handled so far in my career and how I have seen people doing really well, or I've seen people not planning these out well, have actually led to the closing of a startup or the startup going through a very, very rough patch and actually spending extra years trying to just mitigate this particular thing so that they can get to the next steps. So with this, I come back to the first one, which is assumption of IP legalities. As the first point, what I think as every budding entrepreneur, innovator should keep in mind when they are trying to set up or go on their own, launching a great product, a new technology, or a new service, as the case may be. The first one, I like to call is my creation, my right. How many times, being innovators, would you have thought of this that I have created this particular new product, or I have come up with this new technology or with this new design, and now I can proceed the way I want to. So, which means that I would have the freedom to decide when do I tell whom, how do I convey it to people, where all can I convey, right? Let me give you an example of this. There was a group of IIT students, and there is no particular emphasis in saying this, but maybe I should say a group of engineering students who came up with amazing toys, which were scientific toys, and they had amazing designs to the same. So what they were doing is they were making different toys that would enhance knowledge of a child, given they would give more fundamental understanding, life practical exposure and whatnot. The great part of those toys were they were very, very aesthetically pleasant. I mean, if you see them, you would find that they are something that would attract a child immediately the moment the child sees it. So, of course, it was their creation. They had come up with this. They had put in a lot of hard work associated to that. And they felt that now is the right time. Once they have the product being made, the toys being made, they should launch it out in the market. Exactly, they did that. So they got the toys designed, they got it manufactured, and they launched it in the market everywhere. Whether you would go offline stores or you would go online, the toys, some of them were very, very multifunctional. A single thing could act as a table, a chair, a cupboard, etc., whatnot. And once they sold this, some of them were blockbusters. They made good money out of it. They felt, yes, this is the right time for me to now protect my creation. Please mind you, right time for me to protect my creation. And hence they approached us saying that, look, this is what we had made. This is what we had designed. We have these great products. We are now seeing a lot of success in the market. Could you please advise us what all can we do? So when I looked at the product, yes, there was something that was very aesthetically pleasing. So they could go for various design rights. But when I learned the entire story that they've already been selling it out in the market, it's available online, it's available offline, all I could tell them was that they could not protect anything in that. They were looking at my face thinking that, possibly I do not understand what they're trying to explain. I had to explain to them that look, this is just an assumption that you had that this is your creation and hence this is your right to apply it, protect it whenever you like to, in whichever manner you want to. However, the IP laws are very, very straightforward. You cannot go ahead and protect a design or a patent if you've already launched that in public domain, if you've already made commercial benefit out of it. In fact, you should have done the contrary. First, you should have sought for your rights, submitted an application before the respective IP office, and thereafter you should have taken all of these activities which are available for you. I think this was much of a disappointment, but also a learning lesson for them that they shouldn't have really undertaken something without taking consultancy of a professional in that domain. So this assumption has always been a part of the cycle that I've seen in these years, over these years of experience that I've had of my practice, that people believe that because they have created something, they have the ownership of deciding when do they go ahead and file. Unfortunately, when I talk about IP rights, especially patents and designs, it is mandatory under the law that, and this applies not only to India, but across the globe, where the patent offices necessarily mandate the creator, the innovator, that you should first file your rights, your application before the respective authority, and then only should you go out for public disclosure of your invention or design. I now move to the second one, which is ignorance of legal intricacies. So sometimes law is great because law is a lot of common sense, to be very honest. But sometimes not knowing really how do you apply that in a legal context can be damaging. So once there was a case with me where, and I think this was about a decade back, the gentleman had come up with an amazing software tool where he had solved a problem which was pretty much prevalent at that point in time, that you really couldn't have group reservations being done in a hotel if, let's say, you have a group of 10 or more people online. So he had devised various algorithms, etc., and they were working beautifully well. He did great research, tried to figure out which is the biggest market for him, where he should launch and provide the services online, which are the territories or countries where the demand would be high. He found that US would be possibly on the top of the list, followed by a few other countries like China, India, etc. So just true to the core of the research that he did, he went ahead and he submitted that particular application before the US Patent Office, asking for patent rights, and not one actually, but 3-4 applications, each of which were catering to different features that he was offering by way of his website. The amazing thing is when he felt that yes, he is now finding traction in India and that he should now extend the protection to the Indian market as well and file an application before the Indian Patent Office. So he approached us in that regard, asking for advice and saying that, look, can you handle and help me get a few patents here in India? When we started looking at the particular case, we tried to delve deeper and understand from him that he, being an Indian resident, a person who created the entire invention in India, and he directly filed before the US Patent Office. Was there a particular reason? Did he take any kind of license or permission for doing that? He was a little surprised to know that there was something like this, and he just asked, why do I need to do that? Again, here we had to educate him and tell him it is mandatory under the legal provisions of the Indian Patent Act that if there is an invention that is being made in India, the first filing has to be in India before the Indian Patent Office, or you need to have a foreign filing license in place before you go ahead and you submit the same in US. Failing which, you might have to pay. There are penal provisions, both criminal as well as cancellation, where if you happen to submit at a later point in time your application in India, that would be cancelled. Plus the law says that you could be put behind the bars or you might have to pay penalty to the same. And hence, imagine something which was a great revenue traction for the guy. He not only could not file in India, but he had to withdraw his application from the US Patent Office as well. So I would say It is absolutely important for young budding people that yes, please do Google, please educate yourself. But whenever it comes to going ahead with a protection for something that you have done and you want to go ahead, get rights over it, please ensure that you are reaching out to the right people, to the professionals who should be able to guide you better and tell you what should be your next steps and how should you go about it. Do not assume that legally anything and everything is allowed or possible for you to take. The next one that I talk about now is lack of paper trails. How many of you would find this so common that we are sitting with a group of our friends and we happen to talk, discuss some things, and we have amazing ideas that come out of our discussion? Isn't that very common? Isn't it? So this happens all the time, honestly. There are people, especially in the college life or people immediately after the college, who get together, who have these great ideas, who pull in together their idea capital, I would say, and they start working about and they think, let's just go ahead, launch a company, make some money if we are successful, but somehow let's get going and be entrepreneurs. Great, great, great idea. No doubt about it. But I think what would also be better is, along with this idea, if they understand that it's important to have some sort of paper trails when you talk about legal matters like IPRs. Once there was this particular case where a medical support system was being made by a group of engineers still in college, and they made something that was amazing, awesome, and honestly, that particular thing, so far, even I would say, has been quite untouched in the market. They're not very good products available in that particular domain. These were three friends who started working on it as part of their projects during engineering, and slowly, they happened to work upon it and find something that was feasible. And so they submitted a first patent of the many that they wanted to protect that particular feature of their medical apparatus. The first application went through smoothly. Both the friends became co-inventors and co-owners, and they submitted the application. After about 6 months of working together, they had a fight. And a fight such that they separated. They decided that they could not work together. And now the biggest question was, who's going to get the patent? There was no pre-hand decision on how they're going to handle ownership issues in case they happen to separate. And now both of them become each other's competitors. So what do you do with the patent? If you're competitors, largely both of you would need the same patent. But both of you are equally clueless because you do not know what you can do with the patent. And because of that, they happened to abandon the patent because there was nothing clear and none of the two was wanting to put in money. They did not even know if the other person is going to attack them tomorrow, file for opposition, cancellation, etc. And therefore it went down the drain. It's very important at the start that you should have a set paper trail if in case you are multiple people who have gotten together, pool in your resources or your knowledge capital to come up with something that you call or what you assume is your big breakthrough product or service. It's absolutely imperative. False claiming by an insider. So this is again, I'm going to talk about another example where if you don't have a set paper trail, and a paper trail could be in form of an agreement where you put situational things in it or clauses in it where you talk about tomorrow if you separate, this is how the IP is going to be assigned or the person is going to be the owner, or if some false thing happens, then we are going to deal with it in an XYZ manner. So in this particular case of false claiming by an insider, there was a research being done in a particular university and the professor was working with a team of 4 students. They were all doing fairly well, and at certain point in time where they felt that the research was taking good shape and they could find application in dealing with cancer, the professor had approached in order to understand if it was novel enough and they could go ahead and file. We did the patentability assessment and we did find something that was quite similar. So as part of the professional practice, we sent the prior art to the professor citing that, look, this is something that sounds very close to what you've done. Please see and evaluate if this is something you think is making any meaningful sense. Or if this is any different, please provide us the differences between the two. The professor was quite shocked with the citation that we provided. The reason? The reason was very, very simple. In one of the leading journals, the article that we had sent to the professor, actually, one of the students who had quit the team some time back had stolen away all the information and simply gone ahead and published it in a journal, leaving professor with no respite because that became a prior disclosure, and now they could not go ahead and file a patent application. Well, they could have gone ahead and taken the other guy to task, etc., which certainly could have been a legal proceeding. But the case in point was that they did not have due diligences or checks in place. The professor and the student did not have any kind of legal understanding, and it was hard for the professor to take the guy to the next steps, which could be an easy route had they had an agreement and thereafter maybe file a patent also, because the patent law is fairly decent. It says that if somebody falsely claims your invention, then you still have a chance to get the patent in your name. But here, on the contrary, because there was nothing, there were no lab notes with the professor, no agreements, really nothing much could be done here. So as something what you should do, please maintain your lab notes very well. You should have diligent signatures of the investigator or the person who is there before whom you're attending the labs. Have good agreements in place where you are multiple people working together, whether there are teams where you have a professor-student relationship, a faculty working with their students in their cell, etc. It's very, very important and imperative. If tomorrow there is a problem, these things come to your rescue to save you from any kind of, let's say, passing away of your rights. Yet another is lack of due diligence. So a number of the times we would understand. So if I take an example, let's say I have come up with a great algorithm of how I'm going to be channelizing all the information online and how I'm going to categorize it as great information, bad information, or moderate information. And I put the entire algorithm in place that I say that I need some crawlers. The crawlers are going to be looking after a particular product ID or the name of a company. It's then going to be checking about certain adjectives like good, bad, great, etc., poor. And it's going to collect all of that feedback, categorize it, and then provide some awesome results, which are going to be helpful for people in taking a decision whether they should buy a product or not. Let's assume there is an algorithm like this that I come up with. Now, it's absolutely honest that one person cannot be jack of all cards, which means I may be great at devising an algorithm, but that doesn't mean I would be the person who would know how to code it. So I might need external support from people who can go ahead and do the coding of the entire thing. I might need people who have understanding of how they could give some great user interfaces, the graphic part of it, so that it can be more attractive for the people around, etc., etc. So in short, what I'm talking about is there are a lot of times where we have situations where we need external support in order to convert a product or service to a reality. It is absolutely important at that point in time that you have legal agreements in place, clearly identifying who is going to be the owner, who has got what rights, and in what capacity are people coming on board to help you through. Failing which, there might be points where people might say that because we have developed the entire code, the copyright is with us, and we are not going to assign you the rights in the copyright. You do not get the authorship, you do not get the ownership of it. The authorship, of course, remains with the person who has created it, etc., etc. So there could be a lot of IT challenges that you have in place if you do not understand properly that agreements in the first place are absolutely vital. I think the second point I've touched upon in my last slide, where I'm talking about the co-founders need to have great understanding, which is documented and written by way of IP agreements. Origin of startup technology or idea during an employment period. This again is something that I see day in and out in my practice. There are a lot of times when people approach us, and in fact, even in Corona period, in COVID times, we've had so far 3-4 people who've come back saying that, you know what, I work with so-and-so MNC, and I have come up with this particular cure, which is great. And, you know, we are absolutely sure this is going to work. And when you ask them in what capacity would you like to go ahead and apply for a patent or the respective IP right, they would say, actually, we are already working and we are employed with this particular company. And if you ask them, have you checked your employment agreement? Does your agreement say that you can hold patents while you are being employed with the company? Or can you not hold a patent, failing which if you do go ahead, the company has all rights to take away the patents because that's the agreement you've gotten into? I think in most of the cases so far that we have seen, the person has not been able to go ahead simply because your employment agreements dictate a lot in what sense can you go ahead and see if you can protect your IP, have you created one while you were being employed. That's an important thing because a lot of the times people do not do that. But I'm sure being students, being faculty of an educational institute, that may not be a big problem as this kind of a thing may not be there. However, this might come in a different fashion to you where if let's say you're working on a project which is being funded by a company or by a corporate, it is absolutely important to check the clauses as to with whom does the ownership lie if you are working on a project which has been funded by another company. Adoption of non-available brands. This is something again which comes back forth a lot where the companies, they find some catchy words that they think is great for having being adopted as the name of their company or as a product line or a service line. Well, yes, any catchy name is always good, but the catchy name should also be available, which means that if you're simply going ahead and adopting a catchy name because of the phonetics associated or because of a particular design associated to it, and you haven't done a due diligence check in terms of trademarks and domain names, you might simply find that it's going to be a difficult exercise for you tomorrow because not only another company, which is a prior adopter of the mark or the brand, come back and stop you, take you to the court and ask for damages, but you might have to spend a lot of money again building your brand name, changing all of your marketing activities, all of your domain registrations, etc., etc. So be very careful about what steps you take. And all of these steps, if you largely notice so far, what I've been talking about are the steps which you have to do, you have to exercise before you get to the public, before you make a commercial enterprise. In fact, being innovators and especially innovators wanting to be entrepreneurs, I think this is absolutely to understand that every step that you take, every particular action that you foretake is going to have an impact tomorrow in your success or your failure. So better take the path that's going to take you to success and not something that's going to take you to a failure. This is again another very, very common thing where there is overt marketing of products by way of marketing materials, online content, or even public demonstrations. So what people try and do is they try to be absolutely secure. That's exactly what our human tendencies are. Nothing wrong about that. But honestly, if you want to be an entrepreneur, a calculated risk is in order. You will have to do that. You cannot really think that you would get the IP rights, and as well, you would want to be risk averse by first trying to test the market if there are people who would want to take your invention, take the products, or subscribe for your service. So typically people, what they end up doing is they go ahead and launch it in the market, not only in one country, but in multiple countries to see how the product or the service fares. And at some point in time where they see, okay, this is working, they would want to come back and apply for IP rights. This certainly doesn't happen in the design and patent case. In trademarks and copyrights, yes, you could go ahead and file at a later point in time, especially in trademarks. Once you have a usage established, you could file your brand at a later point in time. You just might run a risk that somebody may go ahead and register before you have done that. But in patents and designs, you do not have a second chance. Anything that is first commercially disclosed cannot be redeemed back. But there are certain limitations. If you speak to the person who is a specialist in the field, they might help you understand that if you're making disclosures for research and experimentation, to check whether experimentally your product or service works. There are certain things that can add to your favor, and you can go ahead and stop and not worry about not disclosing it for a certain period of time. Again, all of this needs good advice from a good professional. Oblivious to IP initiatives. I think a lot of the times, yes, like I touched upon in my initial slides as well, money is a problem. In fact, to be honest, let me share this. Money is not a problem only with startups. It's a problem with big established companies as well, sometimes. With startups, it could be more number of times, but I think that's where exactly the entire game is, right? So one of the ways of how you can mitigate is educate yourself. The government is taking good measures. Go back and speak to your innovation cells, especially in universities. The innovation cells are doing a great job. They could help you. They could tell you what are the different grants which are available, different awards available. There are certain laws or certain laws which help you even get some sort of income tax benefit should you start your own firm if you have an IP research set up. The same applies for India also. In India, under the Income Tax Act, there are certain provisions which give you tax waivers if you happen to invest in IPRs. There are a lot of awards, there are incentives where the government is saying that we are going to take XYZ cost, which would come the way of startup, and we are going to fund you. So I think before you take a call that IP is very, very costly to go ahead with, you should explore what are the other options which are available for you, and can you actually rely on those and go ahead and secure your IP in that manner. So far, I think I've touched upon some of the points, and this is there some question for me? Should I stop? Okay. No. So by this slide, so I have so far just spoken about some of the problems that I have genuinely and a number of times seen in my practice that people come up with. And I think, yes, it's a disappointment where because we did not go ahead and initially did our due diligence properly, sometimes very, very great ideas falter. So this could happen in any form of IPR. In fact, IPR is an umbrella term. So by way of this depiction, I'm going to try and explain what you can protect under what head in an IPR, so that accordingly, whatever steps that you should do or don't do, which I just touched upon, they might help you here. So this is a good, great cartoonish car that I would say. And the reason I chose this is because this is a perfect example where I can talk about how a single product could have multiple facets to it, and you could protect each of those facets by way of different IP rights which are available to you as India administers such rights. If I talk about a case in point here, this amazing aesthetic work, which is the look of the car, is something that can be easily protected under industrial designs. Like it's been mentioned here, you could have the exterior or the interior, anything which pertains to the design of a vehicle or a component which has aesthetic value to it could be protected by way of a design right or industrial design as it is called. When we open the bonnet of the car, we see a lot of these components which are being tied or hooked together, wired together, so that you can drive your car the way you like to, right? Which means that your car functions. So anything that leads to functionality, which is a byproduct of the technology which is incorporated, is something that can be protected as way of patents. So you could have your engine, your different components, different technology parts. In fact, the softwares which are synchronizing different parts and making them function and give a particular feature to the car is something that you can apply for patent. I want to mind you here that one patent is only for one invention, which means that every single new feature that you have developed, you could protect that by way of a separate individual patent. One car, it's not surprising, could have several hundreds of patents associated with the technical part of it. In total, the car could have several hundred patents to it. So essentially, the technological innovation is something that you can protect by way of patent. This particular artwork that you see, which I have tagged as trademark, is again something that you can protect for branding yourself. If I just talk about Cadbury's, if I talk about Jaguar, if I talk about Land Rover, you understand, right? They create an image in your mind immediately about the product that we are talking about here. I talk about Coke and you know what we are talking about. So that's exactly what a trademark is. A brand value to your particular product or service that you want to launch is something that you should protect by way of a trademark. It could be by way of a word mark, it could be a logo, or it could be some sort of an artistic depiction of the words and artwork together that you want to protect. Even your taglines are something that are great that should be protected by way of a trademark. If you have different ICs which you have designed yourself, they certainly are something that can be protected under semiconductor topography products. They are semiconductor layout rights for the new layouts that you are being making for this for the ICs, and the protection are being awarded for the same. Besides these, there are certain other IPRs as well, which you could go ahead, but I've only dwelled upon things which are more commercial in nature and which people end up protecting more in order to go ahead and build their enterprise, or to protect various different facets that they develop over a period of time. My last two chips that I would like to point out here is, which are important from the perspective of IP right. One, IP rights are always territorial, which means that if you are protecting a particular patent or a trademark or a design in India, your rights will only be limited to India. If somebody happens to copy that and go ahead and start manufacturing and selling outside India, you would not be able to stop them because your rights are only and only limited to India. So these are territorial in nature. Second, there are different IP offices. So for copyright, you would have to approach a copyright registry. For a patent, you will have to approach a patent office. For a trademark registry, etc., etc. The rules and the forms which are required for filing in each of these cases are as being laid down in the law. In fact, the Indian government portal, which is ipindia.gov.in, actually has good flowcharts where and good bullet pointers where they have very clearly mentioned if you would like to go ahead and file and apply these rights on your own, what different forms you need to furnish to any of these offices. You should, and I encourage you that in case if you're planning to file any of these, you should visit the website, see what those things are, if you are going ahead with filing on your own. With this, I think I'm going to close my discussion and I'd leave the floor open for questions. Thank you. Ma'am, you're not audible.
Okay. Thank you. Thank you, ma'am. It was a wonderful session, and in fact, even I got to know about the various laws and the various experiences that you had. It was a best way of sharing knowledge through examples that you have already witnessed. I am pretty sure our viewers and our students might have gained much information about the patent laws, IP laws through this. We do have some questions, ma'am. Shall I put them forward for you?
Absolutely, please do.
The first question, which I found in the comment section, one student asks, "Do you think that the weak copyright laws in India impact incomes of the parties involved?" They're
Okay,
talking about
so the copyright. Yeah, so Akash has put forward this question. So, Akash, I would like to say here, number one, it's an assumption that copyright laws are weak. Um, I really wouldn't say that copyrights are weak for the simple reason you have to first understand what is the subject matter to which copyrights are being directed to. So, if that is not clear, there is a possibility that we might feel that the rights are weak. Copyright laws are fairly great. I think at some places, yes, there are more clarities which are required when it comes to an overlap of internet service providers, etc. But largely, if they're being exercised well, they do not impact the income of the parties involved. You would in fact hear that there are a lot of these people who are authors and in fact on the basis of whose novels movies etc are being made, or you have got these lyricists etc who have only relied upon copyright laws to get their dues, and they have been able to make good money out of it. You could read upon in Chetan Bhagat's case where you see Three Idiots. He didn't want economic benefit, but he wanted authorship or attribution, which only because of the copyright law he could get. The lyricist group that was being backed by Javed Akhtar, and they could make money because they relied upon copyright law and they enforced their rights related to the same. So I would think that possibly there is certain misunderstanding here, but the copyright laws absolutely strengthen your income. They do not go ahead and make it weak.
Okay, Akash, I hope you have got your answer. Ma'am, another student asks, what are the guidelines to avoid the violation of IPR?
Okay, so this is by Gaurav, I believe. So Gaurav, I would say that there is no particular single document that you would find anywhere that's going to say that these are the guidelines that you have to follow for getting your IPR together. IPR is an umbrella term, and there are 7 particular types of IPRs which are involved. So depending upon what IPR are we talking about, whether it is patents, trademarks, copyright, designs, there are different guidelines in each of these cases, and each of the law actually clearly establishes, outlines what you should do and what you shouldn't do. So in order to understand what are the guidelines, you will have to, for whichever IP right that you are interested in, you will have to read upon a little bit, or you'll have to reach out to the right person who can help you with the same.
Thank you, ma'am. Again, the student asks, what is the best IP strategy for a new startup company?
All right. So if you actually just keep in mind even the things that I've told you today in the PPT, you would make a great IP strategy. Trust me.
Okay. Samrat sir here has put up a question here. Is taking some idea from the internet and then starting its own business is the violation or infringement of IPR? Can that be
Okay.
treated as?
Great. So I think this is a question that has multiple facets to it. Maybe I'm going to take one each. What the facets are. So when you say that you're taking some idea from the internet, let's assume that you're talking about a technological idea, right? Are you implementing that idea as is? Is that free to use idea? Are you making certain changes in technology before you go ahead and launch? Is it something that you have taken which was an open source thing? You will have to figure out a number of questions here. However, most of the times what you get from the internet is, let's say, an object. As an example, I could go online, and if I'm looking for a solution of, let's say, providing a flying robot, right? I go back and I check out if there is a possibility of having a flying robot. And I find a lot of articles that tell me whether there is a possibility that I can construct one flying robot and the components which are required. If I happen to use a particular article available on internet and make a flying robot as is using that article, my next job is not to assume that I'm free of infringement because I have relied on internet. Because then my next job is I need to approach a person who is a professional and see within the filings that a particular country has, for now, let's say in India, is the same solution that I have derived already patented? Because you do not know, you've only relied upon literature which is available on internet. whether that literature that you've relied on internet is something that is being published on its own, is that something that the guy has a patent for, or that guy has copied from somewhere, just put a paper. You need to really see how much freedom to operate do you have for launching that product in the market, considering the IP filings or patent filings for that kind of a product in India. And if after analysis you find that your product is different from the claims of the patents which you have found, certainly feel free to go ahead and use that particular thing, commercially sell it. Simply going by a research publication on internet doesn't really mean that there is a big violation or infringement, unless yes, we are talking about not patents, but we are talking about a copyright or another matter. So like I said, you need to understand the 3-4 things here. Different IPRs are catered to different things. Copyright especially is something which is for literary work. And if you happen to go ahead and, let's say, another case, not of patents, but of copyright, you take somebody's research article and you happen to exactly use that and make audios of the same. Would you be infringing? Yes, you would, because here it's a copyright violation, which is a different thing, judged in a different manner under the copyright law. So please decide what exact thing you have copied, what IP law applies to it, what is the statutory requirement of infringing, not infringing that, and accordingly you would be able to come down and understand whether it is something that you can use or if there is an infringement.
Thank you, ma'am. So I think we are done with the questions.
Yes, sir.
So
A person wants to, a student wants to file a patent. So what are the chances of being the idea and can be used by somebody else? When I am going for filing a patent for some in India, there may be a chance that this idea can be stolen and can be used by somebody else.
Sir,
How
actually,
production for that?
so you'll have to repeat the question. The voice is not coming across clearly.
Okay, I am repeating, ma'am. Suppose
Yeah.
I am trying to put a patent, file a patent. I am having some idea. So while I am filing that, the internal machinery can steal out my idea, and that stolen idea can be used by somebody else and can be filed, and my idea can be rejected in that case. So what is the possibility that how I can get that when I am filing my patent, how my idea is being protected for that? Is there any law and some rules are there how my idea is being protected?
All right. So, sir, there are a couple of things here that we need to understand from the patent perspective. If I talk about India, right? So, India is a first to file country. So, they follow the rule of first to file, which means somebody who has made their invention, and if they are the first one, or in fact, if there are multiple people who happen to be working on a patent, the person who is the first filer is the one who gets the patent right, number one. Now we come to a second scenario where, let's say, there were 2-3 people, and I think I touched upon this in one of my slides as well. There were 2-3 people who were working together on that particular idea, and one of the persons silently stole that idea and filed the patent in his or her own name, leaving the other people bereft of any kind of asset which actually they are entitled as well. So for such malicious incidents, there is a provision under Indian law where you can go ahead and, with your proper documentation in place, you can submit an application before the controller stating the wrong that has been done to you, which is called false claiming, and you can get your name reinstated through that. But if I talk about a third case where we are talking about 2 people who are independently working on same thing, and one of them happens to file before the other, then the second person cannot really go back and say this is wrong because I was also working on this. Because the law is clear, it's first to file. I hope that answers your question.
Thank you, ma'am. Ma'am,
Welcome, sir.
I think from a student's point perspective that in terms of career, if a student of an engineering institute wants to pursue career into IP,
Mhm.
what are the possibilities and how they have to go through for that?
All right, great. So I think that's a very, very good question, sir. That's actually need of the hour because it's important that students understand that this is also one area they can look at seriously. So if I talk about personally myself, I am an electronics telecommunication engineer. So academically, even today, I'm an engineer. Yes, I did my law 5 years later. I'm a registered Indian patent agent, which you get a particular certificate post being an expert in a patent law in India. But largely academically, I'm still an engineer, right? All the people who are working in my team in the patents group are technical people. So I have people who have specialization in biotechnology, in mechanical, in IT, in electronics, and largely that would fare across in IP, whatever firms or companies which operate. Because for us to be able to deal with any invention, the most important thing is that we understand that invention. And I'm sure that you appreciate that if you do not have a background in technology, you would not be able to appreciate the invention, right? You might try your best, but to be able to appreciate the invention, understand it from the perspective of a plethora of technical papers is absolutely not possible. So, yes, this is one area where students can absolutely go ahead and explore this as a career line, number one. Number two, because I've been now here for a while and I've been practicing, so I'm going to touch 2 decades now. I have seen also facets which are very, very thrilling in the sense. So I have done myself campuses in my previous companies at IITs, etc. Even now we do campuses recruitments across in a number of institutes. When people join as freshers, if what happens, because this is the common question that students pose, ma'am, what if we don't like this? This is not simple technology. This is technology being read from the purview of the law. So if we don't like this mixture of a technology or law, I can assure them that they would only enhance their knowledge. One, a lot of the misnomers which are there would be bursted. I personally know my juniors who have worked in IP field for 4 years, 5 years, and today they're running successful companies which have been now in the market for 8, 10 years. And the great part is having worked there in IP field for the initial part, I think they are now being able to protect every single thing that they're doing in a perfect way because they are more knowledgeable compared to a normal entrepreneur who doesn't even know what IPRs are or who has little vague understanding. Now, when they're hand in hand doing it, they are also able to use this lot of patent literature which is there. So, a case in point could be that when in my previous organization, I was working with Fortune 50 companies, I was directly dealing with their general global legal councils or IPR councils, who were the head of these billions of dollars of companies. You have an exposure of how they run IPRs, right? Or how crucial is IPR, how they focus upon coming up with a new product in the market. And the only two legs that help them the most is their core R&D division, which is coming up with new technology or a refined product, but also the help of their patent teams who are helping them harness innovations or understand what they can do new by whatever patent literature that is available to see how that can give them some leaps or some leads what they could do next in their particular thing. So I think that particular combination is always helpful. Do you want to be a patent professional or an IPR professional? Great, yes, there are enough opportunities. If not, you do not like it after practicing after a few years, you have actually only increased your asset capital, both in terms of knowledge and otherwise, because the demand is more. People understand that you know more than what really just a normal technical person would. It helps you in setting up your own, ongoing on your own.
Okay, thank you.
Okay, ma'am, there's Akash, but I feel he keeps more interest in this IPRs. He has posed one more question, if at all you do not mind.
I don't
Can I
mind.
put it?
Yes, yes,
Ma'am, he has a
absolutely none.
question. While starting a startup, can we make our own IPR rules and agreements, or do we have to follow some fixed guidelines?
All right. So I think this is a great question, Akash. So given that you are asking me this question means that somewhere you think you can make your own guidelines, right? Well, so let me ask you this. If you go and buy a particular product, right? Or let's say if you go and buy a piece of land, or if you have a piece of land already there at home, what is it? Is it something that you can just say that, okay, I have gone paid for this particular thing to XYZ person and now this is mine? Or I have just paid, so this is mine? Or do you say, no, there is a particular set guideline by a government which says you have to approach the registry, pay the money, pay the stamp duty, have a particular agreement in place, and then only once all of that is being done, do you say that you are a owner of a piece of a land, isn't it? So that means there is this government who tells you how exactly you have to go about the entire procedure, and then only something that you call yours becomes yours, right? The same is exactly with IPRs. IPRs are also assets. These are assets that become your assets only once you go ahead and get such registrations from the government, from the respective departments of the offices of the government, who have prescribed the set of rules and guidelines that you need to follow so that they can grant you your assets. So you cannot go ahead and change the rules the way you would like to, but you will have to follow the rules of the patent office, of the trademark registry, of the copyright registry, etc., to get a grant.
Okay, ma'am. So I think, Akash, your queries have been very well answered, and we hope that you come forward in this field in the near future. Just like we have our expert. She is also an engineer in EC branch. Yes, ma'am. Sorry.
Right. Thank you so
Thank you so
much.
much. This was a very informative session on IPRs. IPRs are the need of the day when Government of India as well as globally, the need of new ideas, innovations, and the need of conversion of these ideas into enterprises, business enterprises, beginning a platform to employ some more people and cater to the need of people. I think this platform of IPRs is going to help our new budding engineers and people who come up with new ideas to in a proper channel. So, ma'am, all your expertise might have had helped us students and viewers today, and it would have led them somewhere ahead in their knowledge of IPRs, and possibly with all the students who will come up with their innovative ideas in the coming future. We hope so. So, the expertise that you've shared might help them a lot. Thank you so much, ma'am, for giving us your precious time and
It
training
was
our
a pleasure
students.
to. Thank you so much, ma'am. It was a pleasure to be part of this, and I'm happy I could contribute 2 cents. Always a pleasure to interact.
Thank you, ma'am. And definitely we will be in touch with you. And as and when required, we will be asking you and taking your help for our students. Thank you very much, ma'am. Thank you very much.
My pleasure. Absolutely, sir. All right. Thank you.
We'll